Welcome all to the Law Offices of Mary Kennedy. This is an important topic that we are going to be discussing. I have Sanjana from our team as well to talk about it.
So, Ms. Kennedy, what is an NTA and when does a non-immigrant like an H-1B holder receive one? What does it look like?
Right, just to make it very simple, NTA is a notice to appear before an immigration judge. Not many times, NTA is very common for other reasons. We don't want to go into the other details, but recently the situation is many of the H-1B who has been withdrawn of a H-1B, that's a pattern. We don't have any data as of now from the USCIS, but we do recently see that a person who has been terminated of their H-1B and the employer has withdrawn their H-1B, those of the individuals who are in the grace period, that's a discussion point of today, are receiving an NTA, which is a notice to appear before an immigration judge. Why is it, and is that a common situation, which is not common, which didn't happen any time earlier? And let's talk more about the 60 days grace period. Sanjana, if you can just a little bit elaborate the rule from 2016, that helps people to understand what's the 60 days period that has been allowed till now.
Sure, Ms. Kennedy. So, an H-1B worker who has been terminated or laid off or voluntarily separated from their job is allowed a 60-day grace period from the date of cessation of employment. This exact date is determined by the date on which your last payroll was run and the date on your relieving letter. So when it comes to the grant of the 60-day discretionary grace period, we have dealt with multiple cases at our office. However,
from the period of 2016 till now, if we practically speaking, any time we didn't see that, that's the curiosity that we do have, and the reason for this, we have never seen USCIS denying or issuing an NTA, or there are certain situations, even 60th day USCIS received the H-1B transfer or a change of status, and which never saw any of them getting in NTAs or even USCIS denying their change of status or an extension of status when it was filed. And we had been practically able to get them onto the continuity of extension of status over here. So the surprising part right now is whether USCIS is aware of it, or what is the reason, or this is going to be the pattern. And Sanjana, let's talk about the discretionary authority of the USCIS based on the 2016 rule. Can you just a little bit talk about it, and then we'll continue the conversation?
Sure, Ms. Kennedy. So the grant of the 60-day grace period is discretionary by USCIS, meaning that if you're applying for an H-1B transfer and you're submitting all the evidence like the pay slips to show that you've maintained your status up till the date of the termination of employment, USCIS can grant you an extension of stay and consider you to be in valid status. We have dealt with multiple petitions at our office, and never has this been an issue as long as the candidate is able to prove that they've maintained their status during the 60-day grace period. It has not been an issue at all. However, if you look at the official text given by USCIS, it does state that the 60-day grace period is discretionary, meaning that USCIS does have the ability to deny the maintenance of status. In this case, we are seeing reports. We have not seen it at our office, but we are seeing reports of people receiving NTAs during this discretionary 60-day grace period.
That's right, very right. We did go back to the federal rule text and then saw that it's a discretion, but practically speaking, we didn't have any problem until this point of time. As we always discuss, the USCIS has been following certain patterns and then the practices, which we always try to educate our employees, and what should be the next step in case if you receive an NTA, and then what are you supposed to do, how serious this is going to be on your continuity of your stay now.
So we would advise you, if you received an NTA, do not depart the US, consult an immigration attorney immediately. Because once you've received the NTA, once it has been issued, you cannot depart the US because the matter has moved to the immigration court essentially. In case you would like to opt for voluntary departure, you need to attend the hearing. Based on the notice to appear, you can attend it with your attorney, and you would need to make a verbatim statement explaining that you wish to depart the country and you would need to give this in written form. There are a lot of procedures that need to be followed in case you do wish to depart the country voluntarily. But in case you've received an NTA, do not take this lightly. Please do consult an immigration attorney before taking any steps.
Coming back to that, even if you have a change of status that has been approved, that doesn't mean that you have everything in place and you cannot leave the country or you cannot continuity of the change of status. So you have to be very careful, consult an attorney, and we hope that USCIS clarifies sooner or later about what's happening. We see scenarios from the other attorneys start stating that the immigration judge is not aware of what they are supposed to do in this kind of a places. Immigration attorney who can appear for you is very important, and please take that step to do that. And what should be the possibilities, or what should you do? Is it something that we are going to be asking you not to even change your status after you pass on the 60 days or leave the country as soon as you got terminated? What is your thoughts on this, Sanjana?
So there is no clear data on what is triggering these NTAs. It could be when the beneficiary files a change of status with USCIS after their employment has been terminated, that sends an alert to USCIS. It could also be the withdrawal of the H-1B once USCIS receives the withdrawal request from the employer. But again, this is all speculation. There is no official data published on this. Filing a change of status, it cannot automatically trigger an NTA, but it is definitely case specific. It depends on how USCIS is interpreting the individual status during that time. So we would definitely advise to collect all evidence that you have available to prove that you maintained your status during your H-1B. And this includes having pay slips available to document your last date of employment, when your last payroll was run, your termination letter from your employer, which clearly states your last day of employment.
Yeah, that's right, Sanjana. Definitely, please follow the steps so that you are in a safer place, explaining your situation, that you have maintained your status by then. And each individual, this is a very subjective question, so you need to consult an immigration attorney. We are also planning on doing some other webinars for our clients, and this could be circulated within your friends and other details. And coming back to the last question on this, if you have filed your NTA at the same time, you have an offer from a prospective employer on a H-1B, what could be our advice to those kind of a situation?
So we don't want employers to rule out candidates just because they have an NTA that has been issued to them. We would advise, if you've received one, do contact an immigration attorney, and there are steps to overcome it. It should not be used as a ground to disqualify candidates. Ms. Kennedy, what are your thoughts on this?
That's definitely right. As USCIS still has the more discretionary power on that, and then even with an NTA, if USCIS is able to approve the H-1B, then it's definitely something that you should explore that option. When you have a valid offer, we do understand how it matters for you as an individual. So as an employer, if you're ready to file for it, of somebody, of a beneficiary, you should definitely move forward and file for their H-1B and try it out. And further details definitely can be contacted for us, and we will definitely guide you on that.
Thank you, Ms. Kennedy. So we have questions from individuals who are asking, can I continue to work while I have an NTA? Is it better for me to depart the country within the grace period better than trying to change status and risk an NTA? So, Ms. Kennedy, would you happen to have anything to say on this matter, or would you advise our clients to take a consultation if they would require any specialized advice?
Definitely, as it becomes more and more subjective, as we did earlier when it happened with the F1 revocations and everything, we did our best to support each one of them. We didn't even charge any consultation fees, but you are in a situation, we'll do our best to guide you and support you, understanding how valuable it will be.
Thank you, Ms. Kennedy. And we've got one last question here. To close it off on a general note, what's your advice to H-1B workers right now who are in between jobs or they're fearing layoff?
Do your best, connect with your employer. If you don't have a payroll that is being run and then you're at a loss of maintenance of status, definitely you shouldn't be continuing your stay without consulting an employer and attorney. Just, do your best. That matters a lot for you, even if you have to return back to your home country and back over here. Maintenance of status is so important. So please follow rules and regulations. Hope this is helpful for you to understand, and anytime please reach out through an email and we will definitely be glad to provide you the support. Thank you all.